Your Honor, I think that the panel has picked up on one of the salient points here in that what Brion calls for is the involvement of a neutral, detached judicial official prior to the granting of permission for an in-home consensual intercept.
But if you look at the specific language, the 57042 little a and little 4, and it starts with the term if an oral interception, and then goes on to what has to happen. That's in the singular. And if we're going to strictly construe this provision, this seems to say you get one oral interception, you don't get a series of oral interceptions.
I would agree that that is in the singular, Your Honor. However, I think that that may be a little broad of an interpretation of the use of the singular in that particular circumstance. I think we should look more broadly at the circumstances of this case in particular, where the Commonwealth went to a judicial official, laid out very specifically the relationship between the informant and the target of the investigation, reasons to believe that their interaction was ongoing in illegal activity, and also the reason that it was necessary for the interceptions to continue for some period of time. The court certainly, if it felt it would have only been appropriate to authorize one interception, was within its power to do so. However, the court, using its best judgment, obviously decided that the 30-day period of interception was appropriate and authorized that, and then not only authorized it initially, went back and reauthorized it.
Well, Mr. Sematic, let's look at some of the concerns that we raised with Mr. Boaz. When we have a traditional wiretap, there are a number of hoops that the Commonwealth has to jump through in order to get it, including that we've tried all other traditional ways, there's no other source by which we can get this information, etc. And that's not required in this. And after the order is entered in a traditional wiretap, the Commonwealth has to make periodic reports to continue to show that they're getting information. There's continual probable cause. They're required to minimize a conversation if it deals with things that are not covered by the order. None of that protection is given in this case, and a person's home, as the Pennsylvania Supreme Court said, is sacrosanct. And here we're having no protection. So this confidential informant can get communications with no requirement of minimization, no requirement of ongoing probable cause. How do we ignore those constitutional protections in this circumstance?
And it's not just communications. He's in someone's home. So what he sees when he's in there too is also open to police exposure.
I'm sorry. I'm not sure that minimization is necessarily an applicable concern in this instance, given that the target is only having communication with one individual with whom he has...
Well, what if the individual, the defendant in this case, starts talking about something totally unrelated, something personal, something, the government gets it all. There's no requirement and no protection.
But that would be a concern with any in-home consensual. I mean,
can it be justified on the basis that at least one of the parties to the conversation here is consenting to it?
I think
that alter the constitutional standard.
I think that is a factor, Your Honor, and I think in certain ways it could be argued that the non-consensual wiretap intercept is potentially in some ways more invasive than in-home consensual.
Well, yeah, but if you were going to meet him at the McDonald's, maybe, but this isn't a person's house. I just know that our Supreme Court has made it very clear that the Pennsylvania Constitution gives a higher protection to privacy, and especially in a person's home. And you're not meeting him at McDonald's, you're in his house for 30 days.
You can't have an in-home intercept, oral or audio, audio or visual, without one person consenting, presumably. They have to be wired or have a camera on them.
Yes, that is correct. And obviously...
So we should let these people into our homes and let them collect information and intercept our conversations on behalf of the police without the protections that are given to non-consensual?
I think it may be a subject for consideration that the target chose to invite this individual into his home for the purpose of conducting illegal business. Constitutionally, how that weighs in, I'm not entirely certain, but I think that's certainly, from a visceral standpoint, a factor. I mean, he chose to invite this individual into his home to conspire to conduct illegal activity.
So let me still ask two related things. Is there any principle in constitutional law that would say that there's absolute immunity for what happens inside a person's house?
I don't believe that there is
not.
so.
All right, but you need probable cause.
Correct.
All right, if the intercept is authorized for 30 days, but after 15 days of a CI going in and intercepting, it becomes apparent that the basis for probable cause no longer exists. Is the government and the CI still entitled to stay in there for the remainder of that time?
In that instance, Your Honor, I'm not so sure that we would continue that investigation. If it was seeming not to bear fruit, I'm not sure. I guess that would
You
simply...
had been in his home a year before that with no resolve, correct? The interception at that time ceased due to lack of incriminating or illegal communications.
That is correct.
Second crack at it.
Well, I think, I'm not sure I would phrase it that way, Your Honor. I think that new evidence came to light that indicated this may be a viable investigatory tactic. So at that point, again, went to the common pleas court and received...
Well, why isn't it, how hard would it be? You had information that he was going to get paid at 8 o'clock, or there was going to be some conversation about payment. So you get the authority to go in and let him record that 8 o'clock conversation. And then when he comes out, he says, you know, next week on Tuesday, we're going to do, how hard is it to go back to the court and ask for a new order as you would a search warrant?
Well, Your Honor, I think that may be more difficult than it might appear at first blush, given just simply the fact that the target can tell the defendant, no, come back later, come back next week, I'm going to Florida. To some extent, the target is in control of this scenario. He obviously has the prerogative to dictate who can come into his home and when. You know, if the police go to somebody's door for a search warrant, knock, and they say come back later, the police are not going to say, you know, okay, we'll come back later. Just sort of apples and oranges in that respect. And also...
The theme, though, that underlies all of these questions and which makes this permissible is the continuing requirement that there be probable cause for this.
Well, and I think, given what was outlined to the Court of Common Pleas, the court was satisfied that probable cause was likely to endure for that 30-day period. And again, when the Commonwealth went back and had that order renewed, I think the court was also satisfied that the conduct was ongoing and continuing. So, I mean, to me, maybe I'm being overly simplistic, I think this boils down to the fact that you had a neutral, detached judicial official making the probable cause determination, and I think that that is what
And the statute
Brion
doesn't,
requires.
the statute doesn't say that there has to be a time limit.
No, the statute is silent. There is nothing in the statute that would preclude that, and I think from a constitutional perspective, the involvement of the Court of Common Pleas authorizing this makes it constitutionally permissible.
Counsel, what if we, excuse me, what if we agree with the appellant that this was unconstitutional? Was it harmless error with regard to appellant's convictions?
I believe that it was, Your Honor, and as I touched on in my brief in greater detail. If you excise all portions of the affidavit that pertain to the search warrant that had anything to do with any recording, probable cause still exists. Largely, these paragraphs were, you know, on such and such a date, the informant went in, had a particular conversation, law enforcement officers observed X, Y, and Z, also a recording was made. The fact that a recording was made and the contents of that recording were in no way integral to the affidavit of probable cause. It was just, frankly, sort of thrown in there as an aside. The court was made aware that there was a recording, but the contents of the recording, I think in no way sort of provided the substance of the probable cause for the search warrant itself. So,
What's your response to Mr. Boaz's analogy of this type of search to a regular search warrant, where for it to be constitutionally permissible, you only get one shot. You get to go in once, you get to do the search, and that's the end of it. How does this situation differ that it's possible to tell the trial court, yeah, I need this for an extended period of time and still be constitutional?
well, I think as I touched on earlier, in this scenario, things are sort of at the mercy of the target. He has much more discretion to dictate when these conversations are going to take place, when these interactions are going to take place, these transactions. than he would in a warrant scenario where, like it or not, the police are coming in. And I think, to me, that sort of makes it an apples and oranges comparison, just due to the amount of, I guess for lack of a better term, leeway that the target has in sort of guiding how these things are all going to develop and progress. And certainly a factor along those lines is that the ways investigations go, you're trying to work your way up the food chain. Typically your informant, whoever's wearing the wire, is going to be in some sense or another subservient to the target. And the target is going to be in a position to dictate when these things are going to occur. So we think, looking at all the practicalities, law enforcement would be very hamstrung, almost to the point of eviscerating the statute if it was required to get approval for every single in-home consensual intercept. It would be, obviously a huge burden on law enforcement, a huge burden on the judiciary, and just, the practicalities of law enforcement and investigation. It would just be really highly impractical. And I know that is not, that in no way overrides constitutional concerns. But again, I think the constitutional concerns were addressed by the involvement of the Court of Common Pleas.
May I just ask for a point of clarification?
Sure.
This case involved the authorization of a 30-day intercept and then a number of extensions.
Yes.
Does this case lend itself to any type of analysis that would produce different results between the initial intercept period and the subsequent extensions?
I don't believe that it would, Your Honor, in that the extensions in large part, or maybe in total, rested on the same information that was contained in the initial application for the 30-day period. It was just simply a sort of an ongoing, continuing scenario investigation, whatever you will. I think that, again, at any time, if the Court of Common Pleas wanted to weigh in and say enough's enough, I'm putting a stop to this, he certainly had that prerogative and obviously chose not to do so.
Thank you, counsel. You have 2 minutes, sir.
First of all, the reality is that what Judge Blahovic signed in Westmoreland County was the order that was attached by the Attorney General. It's not like he gave this some thought and said, let's see, I'm going to let them intercept for 30 days. The Attorney General's office filed for the search warrant, attached an order, and the judge signed the order without making a single change.
And if he had said, all right, I'm not going to give you 30 days, I'm going to give you 20 days, what would your response be?
My response would be, he can authorize one search. And if he gave 30, 60, or 10, anything beyond one search is no good. In the statute, and Judge DeBow, you were right, it's all written in the singular. And that's important because it's of constitutional dimension. And if we go back to a search warrant, if it was never codified, this wouldn't even be an issue. Commonwealth v. Bruno, Supreme Court case, one probable cause, one search. Codifying it doesn't remove the constitutional constraints on the court. They're still the same. So as long as they got a longer period of time for unlimited searches, whether it was unlimited in 10 days, 20 days, or 30, it's no good. This idea that the statute doesn't say you can only do one is, I think, backwards. The statute has to say, like the wiretap one does, that you can do it for 30 days. They refer to a statute in their brief about putting a GPS tracking device on a car. That statute says it can continue for 90 days. The burden is on the statute to say how long it is. If it doesn't say how long, it has to be treated like a traditional search warrant. On probable cause, one search. So this time limit business not being in the statute really inures to our benefit, because as we see from the non-consensual monitor and the GPS tracking statute, when the legislature wants it to be longer, they put in the time limit. This is a search warrant. Whether you call it a court order, whether you call it statutory or constitutional, it's essentially a search warrant. One showing of probable cause, one search.
What's a search? One conversation, 2 conversations, what's a search?
Well, I'm not so sure that if he gave a conversation and then said, I've got to go to the bathroom, and then came out and continued it, I'd have a great leg to stand on. But coming back 7 different times over a period of 2 or 3 months, which is what they did here, is a lot different than 2 conversations in a 5-minute period.
Thank you. Counsel, before you leave, Judge Bender has recused from this case, and the 8 judges will be making a determination in this case. Thank you.